case briefs, and so much more. LSData's got what you're looking for.
In a 2009 case heard by the Court of Appeals of Maryland, Questar Builders, Inc. v. CB Flooring, LLC, the court emphasized that parties must act fairly and in good faith when exercising their discretion to terminate a contract, and termination for convenience cannot be used to terminate a subcontract for any reason. The dispute between CB Flooring and Questar Builders stemmed from the installation of carpet at a luxury complex in Maryland. Questar had hired CB Flooring for $1,120,000 to install carpeting in 120 garage townhomes, 212 apartments, and common areas. However, when CB Flooring requested a price increase due to a change in carpeting requested by the interior designer, Questar terminated the subcontract. The trial judge initially ruled that CB Flooring had not breached the contract, and that Questar did not terminate for convenience, even though paragraphs 12 and 14 of the subcontract addressed breach and termination for convenience respectively. This case ultimately revolved around the enforceability of termination for convenience clauses and the duty to act in good faith. The Court of Appeals held that Questar breached the subcontract by failing to exercise good faith in terminating. The case was remanded to the Circuit Court to determine the validity of Questar's claim and reconcile bid items. The final costs of the case would depend on the outcome of the retrial.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.